Fulton County District Attorney Fani Willis has just filed a brief with the court saying, look, this whole thing that we've been seeing with Donald Trump and his co-defendants attacking the district attorney, attacking her personal life, that's not what this is about. Let's focus on what the actual standard here is, and let's focus on case law. This is a court of law, not a court of rumor, not a court of innuendo, not a court of gossip. Let's focus on the standard of proof required to disqualify a district attorney who is a constitutional officer elected by we the people, or in this case, the people of Fulton County, Georgia, who want Fulton County District Attorney Fani Willis to enforce the law. So this brief basically says, here's the legal standard. Here, Judge McAfee, is what you need to focus on, not this nonsense. You should not be focusing on things like Donald Trump's lawyer, Steve Sadow, talking about daddy this and daddy that, and just acting so abrasive and frankly so unprofessional. Here, play this clip.
No one knew that there was a relationship between Wade and Willis, according to Wade and Willis. Not a soul was ever told that they were dating or that there was an intimate relationship. Ever. They concealed it from all parties. From Daddy. Daddy didn't even know they had a relationship. Suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hateville. They didn't meet anywhere that would allow the public to see them.
And all of these personal attacks on Fulton County District Attorney Fani Willis that unfolded during these proceedings that bore little resemblance to actually credible legal proceedings where there should be threshold issues regarding standards of proof and conflict of interest. Folks, here's what I want to be very clear about. If there was a conflict of interest that actually existed, I'm going to go through what Fulton County District Attorney Fani Willis talks about in this brief, a real conflict, then sure, I understand the seriousness of it. If there is proof with people who have personal knowledge under penalty of perjury of lies, and that's demonstrated through credible evidence, sure, I have a problem with that. But when you talk about when two adults who were involved in a consensual adult relationship, when the relationship started, and what adults who work together are not allowed to have relationships, meanwhile, Donald Trump, a co-defendant in this case who tried to overthrow a free and fair election, and separately an adjudicated rapist, is allowed to just delay cases and then turn a case involving his attempt to overthrow an election into some personal attack on Fani Willis. It's absolutely reprehensible. And just remember, this is what Fani Willis testified to on the stand. Play this clip.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
Well, no. Look, I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
And then you had someone who used to be close to Nathan Wade, who's the individual who's a special counsel on Fulton County District Attorney Fani Willis's team. But Ashley Merchant, one of the lawyers for Trump's co-defendant, Michael Roman. There's a photo of her right there wearing the Nathan Wade gear. You see her wearing that right there. She used to be a supporter of Nathan Wade. Now she's arguing that he's not qualified enough to prosecute her own client. Like, what are you even talking about right there? And by the way, Nathan Wade had to testify and say things like this. Here, play this clip.
I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No.
2020, that was during the COVID pandemic, correct?
It was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. In 2020, and a portion of 21, I was battling cancer. And that prevented me from pretty much leaving environments that aren't sterile, and I just
I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Taking a look at the brief that was filed by Fulton County District Attorney Fani Willis, here's what they say. State supplemental brief following the hearing on March 1st, 2024. It says, at the hearing on March 1, 2024, concerning defendant's motion to disqualify district attorney, the court posed several questions to the parties concerning the standard of proof. Standard of proof, that's what this is all about, required for disqualification and the legal standards to be applied by the court. The binding case law in Georgia is clear. A trial court is not authorized to disqualify an elected district attorney absent a showing of a high standard of proof that such elected district attorney either has an actual conflict or has engaged in forensic misconduct. Actual conflict or forensic misconduct. And this brief addresses that. Goes on to cite case law that a threshold member, an elected district attorney, is not merely a prosecuting attorney. She is a constitutional officer, and there is only one such officer in each judicial district. That's why the standard to remove a democratically elected prosecutor should be set high. Then Fulton County District Attorney Fani Willis sets forth different types of cases where there have been disqualifications that have been cited by Trump and his co-defendants. So the first set of cases that Fani Willis says, we got to go into the case law here, see what the law is. The first set of cases involve criminal defense attorneys, not prosecutors, criminal defense attorneys who were disqualified on the basis of divided loyalty in violation of the Georgia rules of professional conduct relating to representation of individual clients. And these cases do not apply to the disqualification of a constitutional officer whose loyalty lies with seeking justice, not with any individual private client. So there's a case called Regist v. State, where the Georgia Supreme Court upheld the disqualification of, again, a criminal defense attorney, not a prosecutor, who had previously been directly involved in the defendant's prosecution, including filing an application for search warrants against the defendant. The court held that the circumstances implicated ethical rules that specifically prohibited the attorney's representation of the defendant because the representation created significant risk that the lawyer's duties to a former client will materially and adversely affect representation of a present client. So that has nothing to do with a prosecutor's conflict of interest. Okay, well, let's go to prosecutor conflict of interest. So the cases that involve prosecutors with personal interest in the outcome of a proceedings demonstrate that there is no disqualifying conflict here. So this next category of cases that Trump and his co-defendants rely on involve cases where prosecutors acquire personal interest in the outcome of a proceeding. So you have a case called the Greater Georgia Amusements v. State and Amusement Sales, Inc., where special prosecutors were disqualified from civil asset forfeiture proceedings where they were paid on a contingency fee basis. And while Greater Georgia American or Amusements refers to the appearance of a conflict of interest necessarily created by such a contingency fee arrangement, that case was ultimately decided on public policy grounds, not on conflict of interest. So that reference is what's called dicta, application of a legal standard that the court merely assumed and explicitly did not adopt. But again, that case involved a contingency fee arrangement where special prosecutors were getting paid money based on going after people. That's not what the evidence shows here. What are they trying to say? Because Fani Willis and Nathan Wade took a few vacations, that has a vested interest in the outcome of this case? That makes no sense at all. And it says, in the remaining cases in this category, disqualification was appropriate based on actual conflicts of interest. For example, in a case called in Young versus U.S., special prosecutors in a criminal contempt action were disqualified because they also represented the plaintiff in the underlying civil injunction action. They're representing both sides. that gave rise to the criminal contempt action. So you can't do that. That's clearly a conflict there. And then finally, the last category that Trump and the co-defendants rely on is this case Davenport v. State, which concerns defendants' rights to a fundamentally fair trial. In Davenport, the court held that a defendant charged with shooting her estranged husband was denied a fundamentally fair trial, where the district attorney had previously represented the husband in a divorce proceedings that were pending at the time of the shooting, so that there was a clear and actual conflict right there. And Fani Willis says none of this stuff exists. And look, what this is all about, Donald Trump goes and gives speeches where he makes like sex gestures right now, where he's supposed to talk about, I mean, I assume if you're running for office, what you're doing for the American people, but you got Trump doing this. Play the clip.
And her lover, Nathan Wade. And they hired him for almost $1 million because of his great experience. Of course, he didn't have any experience. He had experience in something else. You know that. A lot of experience.
You know, and that's what MAGA wants to turn our legal system in. That's why I was so disappointed. I was so disappointed to see Judge Scott McAfee allow a circus to take place and not apply the standard of proof. Was there a conflict of interest here that rose to the level of materiality, actual conflict, or forensic misconduct? Not when did you first kiss each other? When does that come on? Come on. That's not law and order in my view, but you tell me what you think. And again, someone lied in declarations. If someone lied, they should be held accountable. I want to be very clear about that. But you need to show that with evidence. When you talk about Terrence Bradley's text messages where he's gossiping, who used to be the business partner of Nathan Wade, that's not evidence of someone gossiping in text messages. Like if Terrence Bradley signed an affidavit under penalty of perjury, that's different. But like, oh my God, did you send a text message? I mean, did you read the entire motion that was filed by the co-defendant? That's not what his role is. That's not what this is about. Anyway, tell me what you think. I'm Ben Meiselas. Hit subscribe. Let's get to 3 million subs together.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.